So, what happens when one country's scientific research looks an awful lot like commercial activity that's been banned for decades? Well, today we are diving deep into a huge case from the world's highest court, a legal showdown between Australia and Japan over the fate of whales in the Antarctic.
Here's how we're going to break it all down. First, we'll cover the facts of the dispute. Then we'll get into the core legal issue. After that, we'll look at the court's verdict and, crucially, its reasoning. We'll also unpack the major legal principle that came out of this case. And finally, cover the court's disposition, what it actually ordered to be done.
All right, so let's start with the facts. How did this high-stakes international legal drama even get started? To understand the case, we've got to understand the history that brought these two nations before the International Court of Justice. So our story really kicks off way back in 1946 with an international treaty to regulate whaling. Fast forward to 1982. Whale populations are in serious trouble, so a global moratorium on commercial whaling is adopted. But here's where it gets complicated. A few years later, Japan starts a scientific whaling program called JARPA. And when that program wrapped up nearly 2 decades later, it was immediately replaced by a much, much bigger version, JARPA 2.
And this is really where the conflict comes to a head. Just look at the difference here. Under that first program, JARPA, the target was around 400 minke whales per year. But with JARPA 2, whoa, that number more than doubles to 850, plus they added fin and humpback whales to the target list. It was this massive escalation that led Australia to say, okay, enough is enough, and take Japan to court. So this brings us to the central legal issue of the case. I mean, the whole thing really revolved around one fundamental question. Was Japan's program genuine science, or was it just commercial whaling wearing a lab coat? Australia's argument was pretty straightforward. They claimed JARPA 2 was, for all intents and purposes, a commercial whaling operation, and that it was a clear breach of the moratorium. Japan's entire defense, on the other hand, hinged on a specific exception in the treaty, Article 8. Now, this article allows a country to grant itself special permits to kill whales for purposes of scientific research, which would make it exempt from all the other rules, including that ban. And that's the million-dollar question, isn't it? What does that phrase, for purposes of scientific research, actually mean in a legal sense? Can a country just decide for itself what counts as science, or is there some kind of objective standard that has to be met? This was the core legal puzzle the court had to solve. Which leads us to the moment of truth, the ruling. After weighing all the facts and the legal arguments, the court delivered its final binding verdict. And the finding was decisive. The court concluded that the special permits Japan granted for JRPIII were not for purposes of scientific research as defined by the convention. Basically, the court said that what Japan was doing didn't qualify for the scientific exception. And here are the consequences of that finding. Since the program wasn't legally scientific, it wasn't exempt from the big rules. The court found that Japan had therefore failed to conform with its obligations under the moratorium on commercial whaling, the moratorium on using factory ships for fin whales, and the flat-out ban on whaling in a Southern Ocean sanctuary. So, that's the what. Now for the really fascinating part, the how. How did the court reach this conclusion? This wasn't just a gut feeling. It was a careful application of legal reasoning. So let's unpack the logic. To get to its answer, the court came up with this really elegant two-step test. First, it asked, does the program even involve stuff that you could call scientific research? The answer to that was yes. But then came the second and much more critical question. Is the way the program is designed and carried out, especially its use of lethal methods, reasonable when you compare it to its own stated scientific goals? And on that standard of reasonableness, JARPA 2 completely fell apart. The court pointed to a few big problems. First, there was no real evidence that Japan had ever seriously looked into non-lethal ways of doing the research. Second, the massive scale, doubling the minke whale take and adding 2 new species, just wasn't scientifically justified. The court also found scant justification for how they decided on their sample sizes. And finally, after all those years, the actual scientific output was described as minimal. And this quote right here, straight from the judgment, is the perfect summary of the court's ratio decidendi, the core legal reason for the decision. It's not that there was no science happening at all. The point was that the evidence just didn't show that the program's design was reasonable for achieving its own scientific goals. Now, this reasoning did more than just shut down a whaling program. It actually established a brand new and really powerful legal doctrine, one that has implications far beyond just this one case. And here is that key principle. The phrase, "for purposes of scientific research," is now an objective standard. This is so important. It means a country can't just say, "our intentions are scientific," and get a free pass. From now on, a court will look at the hard evidence, the program's design, its scale, its methods, its results, and decide objectively if it's reasonable. The state's subjective belief just isn't the test. Okay, so the ruling is in, the legal principle is set. What did the court actually order Japan to do? Let's look at the final disposition of the case. The remedy was crystal clear and legally binding. The court ordered Japan to revoke any and all permits and licenses connected to the JRPA2 program, and it ordered them to refrain from granting any more permits under that specific program. In other words, JRPA2 was over, effective immediately. And that brings us to our final thought. This ruling really drew a line in the sand. It sent a message that scientific exceptions in international treaties aren't a loophole. They're subject to a serious test of reasonableness. And this raises a huge question for international law moving forward. Where else might this powerful new precedent be used? Will other controversial programs now face the same scrutiny? Well, only time is going to tell.